we didn't just tell him he's the only one that owes. We split what we felt they owed as a couple in half. We're holding her responsible for her portion, too.
Where's she working?
Right now, she's not working. She just had a baby.
Listen, I don't want to hear anymore. What property, sir, do you claim that they have that belongs to you that I'm going to want to listen to?
My child's skateboard that we just bought him, a Razor scooter we bought him for his birthday.
Any of those things in your house?
Yes, ma'am.
All right. Make arrangements to give it to his brother within 5 days. Do you understand that?
Yes, ma'am.
What else?
A TV that was ours we had.
That was whose?
Me
Ours?
and Erica's, we
now
shared.
It belongs to her. What else?
Okay. That's it. Just my kids' clothes and stuff. I mean...
You have any of his children's clothes?
Yes, Your Honor.
Very good. Pack them all up along with the 2 toys. He's going to pick them up. 5 days. Do you understand?
Yes, Your Honor.
Don't go near there until your court case is resolved. What do you want?
I have a text message where he admits he owes money to my
Very good. I'm glad to hear that. That's all. Goodbye.
Thank you, Judge Judy.
Parties are excused.
Just a second.
Wait here.
You're not going anywhere. We have to make an appointment for you.
Okay.
Thank you.
Wait right here. Okay.
He was the father of my daughter's son.
I'd love to see my son.
You know, I'm not going to throw my daughter out on the street.
I don't know why they brainwashed her.
I just think it's messed up. I put my parents in this situation.
And I don't know.
He did too, and he knows he owes the money. So.
And now the next case.
All parties in the matter of Cowart versus Foss. Step forward.
Stephen J. Cowart is suing his former friend, Matt Foss, for punching him in the face and breaking his jaw during a camping trip.
Mr. Cowart, you and the defendant used to be friends. I have no idea whether you are still friends, but it is your claim that he assaulted you. You want to be compensated to the tune of $5,000.
Yes, Your Honor.
Tell me.
Well, the night of the incident, I was...
Date?
September 25th, I believe.
Week?
Auburn foreign car.
Were you paid in check or cash?
Check.
Did you work there the week before?
Yes, ma'am.
How much did you earn?
I earn $9.50 an hour.
How much did you earn for the week?
It's a full-time job, 40 hours, 40-plus hours a week.
Are you independently wealthy? Do you live off a trust fund?
No.
Then you would know exactly how much your paycheck was a week.
It was between $250 and $300 every week, every Friday.
Good, then you can pay her back this money. Judgment for the plaintiff in the amount of $400. Thank you very much. That's all.
Parties are excused. You may step out.
Man, Miss Judy treated me dirty.
I don't want anything to do with this kid.
It was nice while it lasted, but I could understand how something like this would screw it up.
He's addicted to many different things, drugs, I don't know.
Ridiculous.
I've known him in the past. He's had issues.
We're all guilty of experimenting.
In the past, it was cocaine, and now I'm aware that it's Oxycontin.
No, I don't abuse any medications.
I trusted him very much, actually.
I think it's gone.
I'm good on my own. I don't need him at all in my life anymore.
And now the next case.
All parties in the matter of Lewis versus Lindsay. Step forward.
23-year-old Krista Lewis is suing her ex-boyfriend, 24-year-old Ronald Lindsay, for a loan for bail after he was arrested on drug possession charges.
Miss Lewis, the defendant was your boyfriend. It's your claim that you bailed him out of jail. He paid you back the initial $300 deposit that you gave to the bail bondsman. It is your claim that he agreed to make periodic payments to the bail bondsman. He didn't do that. You had signed the bond, and they just entered a judgment against you in the amount of a little over $1,000.
Yes.
Mr. Lindsay says that your agreement with him was that he would pay you back for the $300, and in exchange, you would make the periodic payments to the bail bondsman because you were crazy about him, and you were hoping to get back together with... She's an idiot. And shh. And I didn't do 10 years of post-high school education to deal with 4 idiots over a wedding date. So if you got punched in the face and you got hurt, pay your own medical bills. And you have a counterclaim? You shouldn't have gone to the bowling alley.
I agree, Your Honor.
That's right. That's right. You shouldn't have responded to him. You shouldn't have gone. You should have said he's an idiot. My wife's a bit of an idiot. I'm not going to be an idiot. I'm smarter than that. But I'm certainly not going to go to the bowling alley to confront him because that's going to end up in trouble. And if you got socked around, which you say you did, and you got harassed, which you say you did, you've been doing it to each other.
He was never harassed or hit. In the police report, it said he was never hit.
You started it.
I did not.
I'm finishing it. Your case is dismissed. So is yours. Goodbye.
Thank you, Your Honor.
Parties are excused. You may step out.
Him and his wife were harassing my wife.
He did attack me. He assaulted me first.
It's said and done, but
I retaliated in self-defense,
it's not over.
and he cried about it.
And now the next case.
All parties in the matter of Gallegos versus Hillman. Step forward.
Lisa Guy withdrawing the money.
Ms. Gallegos, the defendant is your former husband.
Correct.
And it is your claim that before the divorce, but you only found out about it subsequent to the divorce, that he had deposited a check into a joint account that you had. The check turned out to be not a good check. He withdrew the money, and you are being charged for that amount.
Correct.
Some $3,000 some odd dollars, including fees. I'm not exactly sure what Mr. Peelman's defense is, but he sort of says you should have closed the account, and then you wouldn't have had this trouble. Is that your defense?
Your Honor, anything that she feels I owe her or owed her should have been taken care of in the divorce.
If she knew about it.
If I knew about it.
If she knew about it.
Yes,
You
Your
didn't know about it.
So now you want to talk to him? Go outside. On what date were you divorced?
When was
July
our fi-
23rd, but I physically left them on the 22nd of July.
Okay. So they owe you for a week. Did they pay you?
No.
Okay. So they owe you $1,000 for the ticket and $400 for 1 week. $1,400. That's what they owe you. Didn't work out. That's what you owe her. And your counterclaims for the new nanny and the new nanny's expenses is dismissed. And I suggest you be more careful next
Your
time.
Honor, may I speak on their behalf?
No. Goodbye.
Parties are excused. You may step out.
I think it's fair. It was a blatant lie. They fired me, and obviously when they said it was fair, they believed it because they knew they were wrong and they were lying.
Well, it is what it is, and the fruit doesn't fall that far from the tree.
They're lousy parents, and I feel sorry for their son.
You just got to be really careful of who you pick.
These people are crazy.
Next time we'll be a lot more safe.
I'm young and I'm gonna learn. I'm gonna live. It's no big deal.
And now the next case.
All parties in the matter of Smith versus Allgaier. Step forward, please.
Amber Smith is suing her ex-husband, Austin Allgaier, for a cell phone bill, damaging property, and for stealing money from their son's piggy bank.
Miss Smith, this used to be your husband. You have a child together, a boy.
We do.
It is your claim that subsequent to the divorce, he owes you some money. He owes you some money for a cell phone bill. He owes you some money because he took money out of your son's piggy bank. And he stepped on your present fiance's.
Our family's PS3 controller.
There are a couple of things that I will probably agree with you on. Pronounce your last name for me.
Allgaier.
Mr. Allgaier. One of them is probably the cell phone bill, although I'll hear a little bit of that. But I really, really have a problem with the piggy bank, sir.
Judge Judy continues in a moment.
What do you put it on the floor for? That makes sense to you, Bird? Take it and put it on the floor?
Why would it be on the floor?
I'm not speaking to you. You're an idiot. I don't speak to idiots.